First matter before the court is Cumberland 23-248, estate of Linda Giguere. I see counsel are present. I'm assuming ready to proceed. We are being streamed live on the web, both by audio as well as visual. I think we're a little bit experimenting here. And if you are ready to proceed, counsel, if you could start by identifying yourself, saying your names for the record together with the party that you represent. Let's start with the appellant.
Good afternoon, Your Honor. Adam Shub, Freddie Flaherty, on behalf of the appellants Erik and Mark Giguere.
Thank you.
Good afternoon, Your Honors. Anna Clark of Jensen Baird, representing Hilary Barlow, the appellee.
Thank you. Mr. Shub, if you're ready to proceed, be happy to hear your argument.
May it please the court, good afternoon. As I said, Adam Shub on behalf of the appellants Erik and Mark Giguere. On behalf of Erik and Mark, thank you for the opportunity to be heard. It's quite a privilege to be part of the first video live stream, so thank you, or no thank you, we'll see how that goes. This case really boils down to one thing: Linda Giguere's intent, what she wanted. As this court knows, that's the ultimate goal for interpretation of a will. And what Linda Giguere wanted in this case could not have been more obvious. Article 7 of Linda's will, the 2013 will, says that she has thought of all possible recipients of her bounty, in caps, including my daughter Hilary Barlow, from whom I am estranged, and to them I leave nothing. That's Appendix 91. But rather than reform the will under Section 2805 so that the residue of the estate be distributed to Mark and Erik.
Counsel, I see that the green light is on. See, you shouldn't have spent so much time talking about the video stream. Following up on what you just said, though, although if we even were to interpret the article as saying I want to make clear that I don't give any of my residual estate to Ms. Barlow, it still doesn't say to whom it does go.
No, Your Honor, it doesn't say expressly to whom it does go, which is one of the reasons.
But isn't that equally as important as part of the intent?
I don't think so, Your Honor. If you look at the totality of the evidence, you have the 2012 will that set up a scenario within either case, whether William died first or whether Linda died first, ultimately Hilary Barlow was going to take. The 2013 will makes a number of changes.
And that's the point. It is different.
Right. It removes, Your Honor, it removes Hilary Barlow from the equation in Article 6, and then it removes her from the equation in Article 7.
Counsel, at the trial below, the attorney who drafted this will testified. And that attorney testified that the reason there is not a residuary clause to cover the contingency if Linda survives William is because Linda hadn't made up her mind yet. Now, that's a fact found by the trial court. Don't we have to defer to that?
Not in this case, Your Honor. The Ms. Hunter, who was the attorney who drafted the will, testified that it was a conscious decision. She was asked the question whether it was a conscious decision, whether the scenario where William died first was left out of the will. She answered that question, yes. But the problem is the probate court didn't delve into the rest of the record. And when you compare the label that Attorney Hunter puts on this quote-unquote conscious decision against all of the factual questions that Ms. Hunter was asked at her deposition.
But isn't that the point? It is a fact question, and as Justice Douglas indicated, the probate judge found that to be the fact?
It is a fact question, Your Honor, but when you marshal all of the evidence, in our view, it meets the standard for clear.
And you had a clear and convincing burden, right?
Well, yes, Your Honor. It was
so you have clear and convincing burden, and then you come to us and we have to defer. Those are pretty high standard of review hurdles, aren't they?
They absolutely are, Your Honor. But we think in this case, if the court focuses on the rest of Ms. Hunter's testimony, what you'll find is the conscious decision answer really pales in comparison to what else is in the record. If I could just point out, if you look at page 65 of the appendix, It's page 8 of the deposition transcript. Hunter's asked about meeting with Linda to go over the new will. She says, quote, Mrs. Giguere, I think, called me and said I needed to make a change. I want to take Hilary out, so I had to change Article 6. Article 6 was the provision where Hilary would take in the event that William had died first.
So there's contrary evidence to what the probate judge found, but that doesn't mean that there wasn't evidence to support what the probate judge found.
It doesn't mean that there wasn't evidence to support what the probate judge found, Your Honor, but there was so much more evidence and compelling evidence that
But that's not the standard that we look to, is it? Also, there's no evidence anywhere that Linda intended the stepsons to inherit the residuary if she survived William. I know they're connected into the trust in Article 6, but there's no other provision for them in this will.
Well, Your Honor, Article 6 was the provision that dealt with William surviving.
Correct.
Right? And when the 2013 will was drafted, Hunter removed Barlow from that equation and inserted the brothers.
But the brothers' right only occurs if the trust comes into being. This trust was never activated because William predeceased, right?
Right, and Your Honor, but that's the whole problem, right? We have Linda Giguere, who this is her third will being drafted by Ms. Hunter. In the 2012 will, it dealt with both scenarios.
Okay, but let me just backtrack you here. You said there's no doubt about her intent, but in this instance here, it was very clear that William was failing. His health was going bad. She came in. It's very clear from this will that she wanted to set up something to take care of his health and safety and welfare. In the meantime, she trusted his two sons to do that. Can we take that from the will?
Yes, Your Honor.
And after William would pass away, after having the benefit of the trust, then the sons, presumably to reflect the fact that they had taken care of their father during those years, which is what Linda wanted, get the residual. But this trust never came into being. There's no avenue for the sons to come in. Are you arguing that there is?
We're arguing that there is an avenue for the sons to come in because what Linda Giguere believed she was doing was cutting out Hilary and then having the residue flow to the sons in either scenario.
Well, can I just challenge on that? Cutting out Hilary, she didn't just cut out Hilary, she cut out anybody who could inherit from her bounty. And I suggest to you what she meant by that was if she should predecease William, she didn't want any of her stuff to go anywhere except into that trust for William. So she cut out, I don't remember the exact language of it, anybody who might inherit my bounty, including Hilary. So Hilary had been in the picture beforehand, but it seems clear from the face of the plain language without going to the factual findings that she wanted this trust for William, she cared about him, set it up, and nobody took anything else out of her estate. It all goes into the trust.
Well, it all goes into the trust, but if there's anything left over, Your Honor, it would flow to the brothers.
Only if the trust came into being.
Exactly.
And it didn't.
No, the trust didn't come into being, but when Linda Giguere went to change her will for the final time in 2013, the 2012 will had contemplated both scenarios. So the testimony from
But William's health was declining during that time. It seems her only reason for coming back and tinkering with it is to say, I want everything to go into the trust.
I understand. That's a fair point, Your Honor. The testimony from Ms. Hunter is revealing on this point. Because what you have here is you have Linda Giguere going to her and saying, I want to make these drastic changes. I want to take my daughter, my estranged daughter, out.
I want to take anybody out who can recover.
But the purpose, Ms. Hunter's testimony tracks that the purpose of the call was to take Hilary out specifically. But then in Hunter's testimony, she can't remember whether she even broached the subject with Linda as to what the consequences
But
would
isn't
be.
that the problem? I mean, what I started off with is, even if we accept your premise that the findings of the probate judge are against the weight of the evidence when it comes to whether or not there was an intent to essentially cut out Hilary, there's still very little evidence, if any, in the record to suggest what her intent was for the residual of the estate?
In our view, Your Honor, by adding the boys in 2013, that showed...
Under very specific circumstances.
In very specific circumstances, but that illustrated the intent to elevate the brothers above Hilary, who was being excised all over the will.
Let me ask you, come at it and ask you a little bit different question. Do you agree that under the existing language of the will, just as it is on its face, that will is not effectively disposed of by, that the residuary estate is not effectively disposed of by that will?
Yes.
Okay. So doesn't that bring us to section 2101, that any part of a decedent's estate not effectively disposed of by will passes by intestate succession unless, and I'm going to get to the unless, you can come up with a different theory, right?
Yes, Your Honor.
Okay. So your theory is that under 2805, it should be reformed in accordance with the intent.
Because there's a clear and convincing evidence that there was a mistake made.
And so we are reviewing the sufficiency of the evidence on that point, as well as the fact that, according to you, the terms of the governing instrument were affected by a mistake of fact or law.
That's correct, Your Honor.
Counsel, I don't understand how you can say there's clear and convincing evidence when the attorney testified that there was no scrivener's error, and the attorney testified that Linda had made a conscious decision that she was not prepared to determine where the residuary estate went at the time she executed the 2013 will.
I appreciate your question, Your Honor, but the testimony from Ms. Hunter is more revealing than that. She's asked specific questions about these very important issues that she can't seem to put a finger on. Yes, I acknowledge that there's testimony in the record where she asserts that it was a conscious decision, but she's asked these direct questions at deposition. In 2013, what was the plan for where Linda's assets would go under the 2013 will in the event that William had predeceased her? She says we didn't go there. How could it be a conscious decision on the part of Linda that she walked into the office, walked out of the office, and was comfortable with the fact that this ball was up in the air when they never had the discussion in the first place?
Because she didn't know what she wanted to do. Linda, I think the testimony indicated that Linda hadn't decided yet. She felt she had time, and so she didn't want it committed to writing in the will because she hadn't made up her mind.
She was asked at deposition, did you explain at all the consequences of being silent on this issue? And the testimony from Ms. Hunter was, I don't remember.
Attorney Shub, the 2012 will, the 6 July 2012 will, does contain a residuary clause. I'm referring to Article 7, page 95 of the appendix. Doesn't the presence of a residual clause in the previous will and the absence of a clause in the 2013 will support Ms. Hunter's testimony that the omission was deliberate and not a scrivener's error?
I think it supports the notion that it was a mistake not to fill that gap, Your Honor. Article 7 is what you're referring to at Appendix 95.
Well, what I'm saying is Attorney Hunter and Ms. Giguere clearly knew how to draft a residuary clause, as evidenced in the 2012 will, but they omitted it in the 2013 will. And
they did omit it, but according to Hunter, they never talked about it. And according to Hunter, she never broached the subject. So what we have here is we have Attorney Hunter saying it was a conscious decision, if I may.
You may finish your sentence.
What we have is Attorney Hunter saying it was a conscious decision to leave this ball up in the air, but that's belied by the record, Judge.
Thank you.
Thank you.
Ms. Clark?
Good afternoon. May it please the court. Just as Attorney Shub said, this case boils down to what was Linda's intent, and there is no evidence in this record about what she wanted to happen in the event that she outlived William.
But isn't it clear that there is evidence in the record, in the will, that she really essentially was disinheriting your client?
So that clause says that she leaves Hilary nothing in the will. It does not say that she does not want Hilary to inherit pursuant to the laws of intestacy, which is what is required under the statute currently. So additionally,
You make an interesting point there. I would ask you a hypothetical question, not this case. Can a person execute a will that has one sentence that says, I leave nothing to my son John, signed, thank you, but doesn't make any other provision for distribution of the will? Can that work?
it's an incomplete will, and that's what this is here. We have an incomplete estate plan. Incomplete estate plans happen all the time in the state of Maine.
So you agree the trust portion, which takes up most of the will, is off the table because that trust never came into
Are we
being.
talking about the hypothetical you proposed?
Oh, no, I segued over to the
Okay.
actual case. That's a trick we do in the appellate court here.
So in this scenario, yes, none of anything having to do with the trust came into being because William predeceased Linda here.
So all that's left of this will is, I have in mind all possible recipients of my bounty, including my daughter Hilary Barlow, from whom I'm estranged, unless I specifically mentioned them herein, to them I leave nothing. Basically, the will is that one sentence.
Correct.
But if that is the case, aren't we then under 2101 subsection 2, a will that expressly limits or excludes the right of an individual to succeed to property by intestate succession?
No, Your Honor. I don't believe that is an express exclusion, that Hilary is not to inherit via intestate succession. The language
Which, by the way, wouldn't necessarily leave Mr. Shub's clients in possession either, but...
Correct. Correct. My argument is that there's no avenue here for Attorney Shub's clients to inherit this estate. They are not.
Who gets the estate then? If Hilary can't have it and the sons can't have it?
My
Is it
argument is that
escheat to the
Hilary.
state?
My argument is that Hilary receives it because there's no express provision in this will saying that she is not entitled to this estate.
But just going back to the Chief's question, if that Article 7 knocks Hilary out, it also knocks out everybody else who might be able to claim. I'm just wondering who in the entire universe of the planet gets to inherit.
Although, does it? I mean, it does, would 21012, if it knocks Hilary out, does it knock essentially other heirs, or is it more like she's disclaimed personally?
So
Well, I go to the language of the
Yeah.
provision that says, all other possible recipients of my bounty. That would mean intestate recovery also, or distant relatives?
I don't think that does mean intestacy because the statute says that in order to exclude someone from inheriting via intestacy, it has to be an express exclusion, and that doesn't say the word intestacy anywhere. It doesn't say I exclude them from inheriting in any possible way or form. It says I leave them nothing.
So I'll take you back to the Chief's question that we've been sort of dancing around, which is,
Well, the will seems to expressly refer to Hilary. It doesn't necessarily expressly refer to her issue or other people. I mean,
Correct.
if you look at 2101 subsection 2, it says if the individual, i.e. Hilary, survives the decedent, the share of the decedent's intestate estate to which that individual or class would have succeeded passes as if that individual had disclaimed her share. So don't we then look at who would be the next heirs?
So if there had been an express exclusion in this will saying that that Linda was not leaving anything to Hilary in the will and was also excluding her from receiving via intestate succession, which was not included in this will, then yes, I think Caleb would be the grandson, Hilary's son, and Linda's grandson would be
And I noticed
the
that
next
in your
person.
argument, you sort of referenced that, but it's kind of in passing that might be one of the results.
Yes, I think, to the extent, if there were an express exclusion preventing Hilary from inheriting via intestacy, then I think that would be the next, the person who would inherit here. However, that's not what we have here. We have a will that does not have an express exclusion preventing Hilary from inheriting via intestacy. And
Counsel, is there a question as to which version of the probate code applies here?
I don't think so. Section 8-301 discusses the effective date of the current code that went into effect, I believe, 2019, actually September 1st, 2019. And the statute specifically says that the code applies to any wills of decedents who die on or after the effective date, which is what happened here.
So 18C is
Correct.
applicable. Okay.
If there are no other questions, I yield my time.
They don't appear to be.
Thank you.
Mr. Shub.
Thank you, Your Honor. Just briefly, a couple points. The probate court referenced section 21012 in its order, and court's likely familiar with this, came to the conclusion that the exclusion of Hilary does not expressly exclude or limit Hilary's right to succeed by intestacy. The problem with that is it doesn't track with the comment to the statute. The comment in the statute says that you can exclude somebody for purposes of intestacy by, with an example of saying, quote, I don't want my father to get anything. Well, in this 2013 will, the language is, in reference to Hilary Barlow, I leave nothing. That seems to be a pretty fair comparison, that would work to exclude Hilary from taking an
But do you agree
intestacy.
if 2101 sub 2 applies, it still doesn't give anything to your clients?
No, that on its own doesn't give anything to our clients, Your Honor, but in the overall context of the 2012 will and the 2013 will and the injection of the Giguere brothers in Article 6, we think clearly Ms. Giguere was elevating the brothers over Hilary, and that there's really no other conclusion to reach. Before I conclude, I just wanted to draw the court's attention to Appendix 67, line 15, when Ms. Giguere was, Ms. Hunter was asked, was she, being Ms. Giguere, clear in the discussions with you that based on Article 7, which is the clause we're talking about, that Hilary would not receive anything under the will? And the answer was yes. That demonstrates that Linda understood that Hilary wouldn't receive anything under any circumstances. Thank you.
Thank you. Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. And Ms. Clark, I understand that this is your first in-person argument. In the tradition of the court is that we ask counsel to come on back and take the greetings of the courts.
All right.